You'll, okay, you just got the warning that I was going to give you that we're going to be recording this, but we are. And also, if you have questions, then, well, anyway, let me back up just a minute. So I'm Shari Broder. I'm an arbitrator, mediator, and fact finder, and I live in Freeport, and I chair the Maine Board of Arbitration and Conciliation, and I'm alternate chair of the Maine Labor Relations Board, and a member of the Maine LERA Board, and past president. And I'm very pleased to have with us two people who I will introduce to you in just a moment. And also, I'd just like to thank Emily Smith, who's here from National LERA, and they're hosting this, and so I can pay attention and moderate this. But yeah, so we'll have our discussion first, and then at the end, there will be time for questions and answers. So if you want, you can either pop them in the chat for later, or you can raise your hand when we get to that point and ask them. Some questions are easier asked verbally than in writing, so it's your choice. But anyway, we will have time for that in the end. So so we have Ben Grant is here, and he is general counsel for the Maine Education Association, which, as many of you know, is a statewide labor union that represents 24,000 educators in Maine, including teachers and other professionals in nearly every public school in the state, and faculty and other professional staff in the University of Maine and community college systems. So prior to joining the MEA, Ben worked in private practice at McTeague-Higbee, where he represented many private sector unions in Maine, including the AFL-CIO and the Maine Building Trades Council, and hundreds of employees in the workers' compensation system. Elek Miller is an attorney at Drummond, Woodsum, and McMahon. It's just Drummond, Woodsum. Oh no, you put in McMahon. Is it still okay? I'll go with what you said. He's a lifelong Mainer, minus a short stint in New York City for grad school. And Elek advises public and private sector clients on all manner of labor and employment issues, including employee leaves, workplace disputes, wage and hour questions, employment and separation agreements, and other state and federal legal compliance matters. He also works with employers to draft workplace policies and procedures, and we'll talk about some of those today, and represents employees in front of state and federal administrative agencies and courts. And as chair of Drummond's Privacy and Data Security Practice Group, Elek also assists employers navigating the often complex interplay between technology and the law. And as some of you can see, Emily has posted in the chat that attorneys who want CLE credit, send her your name and bar number if you have it handy, if you want to put it in the chat, and obviously presenters get even more credit. So anyway, so we're going to start with a discussion, and I didn't know, I haven't seen if Rebecca's here yet, but we can make announcements. She can make announcements towards the end. But anyway,
hey, Shari, I'm just going to say hi because you've asked a couple times and I am here.
Okay, great.
Thanks everybody for being here, and I'll come on at the end and announce our next meeting. So you go right ahead. Okay, great. So I guess we just get started with the basic kinds of things, like how would you describe workplace bullying? Or if it's easier to just give examples, then whatever is easiest.
Ben, do you want to go first? Do you want me to? Happy to do.
Why don't you go first, Alec? Go ahead.
Okay. Yeah, I mean, I think there are a couple different ways to think about workplace bullying. One is through sort of the lens of the law, and what laws, when we say workplace bullying, what laws might be implicated, and look at a definition that way. And right in Maine, we have a workplace bullying law specific to school units. And of course, we have anti-harassment, anti-discrimination laws, and you all have probably workplace codes of conduct that establish certain norms within the workplace. And right, all of those could implicate workplace bullying. One definition that I think is pretty good and helpful is, something to the effect of intentional behavior that a reasonable person would generally expect to interfere with an employee's performance or ability to work. That's one way we've actually used that definition in a sample workplace bullying policy we put together for school units under the state law to describe workplace bullying at a high level. But I think it can be a lot of different things potentially.
So, and we will talk about that law a little bit, I hope, as we get into this. Ben, do you want to elaborate on that at all, or?
Yeah, the only twist I put on that is generally I'm looking for a pattern, but I'm also looking for purpose, right? So this is behavior that is repeated and doesn't have a really legitimate purpose in the workplace, and especially I'm sure we'll get to this, but we're also dealing with bullying from the public, from the outside, not just the workplace, but it has to do with the performance of someone's job and the opinion of someone from the outside coming in. So obviously I work for the MEA now, so we're talking largely about educators and what they're doing on the job, and bullying that I would allege is occurring from members of the public that crosses some lines that I think we'll probably get into.
Yeah, yeah, that's a particularly interesting issue, I think. I don't know if you want to talk about it. We could go into it now, about how, well, should we just talk about that law at this, the law governing bullying in schools? And we can get back to some of these other things I was going to ask you.
Sure, Elek, why don't you take it, since you've helped draft some of the policies?
Sure. Yeah, thanks, Ben and Shari. Yeah, so there's a law in Maine that generally prohibits bullying of school employees. And it prohibits bullying by a pretty broad sort of swath of people: students, other staff members, and members of the community, parents, right, other folks, in the towns that make up a particular school unit, community members, etc. And so schools are in a position of trying to, and needing in many cases, if we have an allegation of workplace bullying, to regulate, right, behavior of some folks that they have more control over, like students and other staff members, and then folks they, in many cases, don't have a lot of control over, community members and parents in some cases. And there are all kinds of difficult scenarios and tricky scenarios that come up, but one of the hardest things for schools, I think, right now is figuring out what, if anything, they can do about some of the outside conduct that people engage in. And, there are some things we help them work through, like limiting channels of communication and, right, trying to cordon off and help protect staff members who are, in fact, being bullied from repeated interactions with those individuals in the community, and sending them, another place if there's a place for them to go. Sometimes even having to tell them that, they can no longer communicate through certain channels, in order for the school unit to try to meet its legal obligation to address the bullying if we found that it does exist, which of course there'd be an investigation and a process to determine what's actually going on first. But so that's yeah, as Shari said, an interesting and sometimes difficult area when you're trying to, an employer is trying to regulate the behavior of people outside of the workplace.
Yeah. So, and I don't want to get off on that too much, because it really does. It is kind of a, well, I know both of you are involved with education, and it is something that I think of a lot of us relate to in that arena, as opposed to in other workplace situations. So,
well, I guess, Shari, if I may, one of the reasons I brought it up is it's oftentimes a rare opportunity where the employer and the employees are on the same side of an issue. So when you're getting bullying and harassment from the outside, often that's not discriminating between, a bargaining unit employee and a management employee. It's often both of us. And I know that Elek's firm and the MEA we're on the same side of cases in this area. So that's why I raise it for this group, because it is an area where you can, I think, work constructively with the employer to try to figure out what to do, because the answers are not easy.
That's a really great point. So have you found that there are like certain types of bullies, or does that? fit any kind of a profile or not?
I mean, without getting too political, if I can be diplomatic, it's, people who are angry with something, right? And have chosen not to use a constructive outlet to voice that anger, and instead are trying to either harass, intimidate, make people look bad, frequently using social media, all the things I'm sure people expect me to say.
I would agree with Ben, particularly when we're talking about in the school context, bullies from the outside of the direct school community, not students or staff necessarily, but members of the community. Often the bullying or their conduct anyway takes that form. I've found, aggressive communications in various forms, and sort of going beyond what, at least for a long time, I think a lot of us thought as social norms that would prohibit, or at least inhibit that kind of behavior. And then I found internally, and if we think about bullying sort of generally speaking for any employer where you have employees not getting along, or you have a manager and a subordinate, and the subordinate may not like the manager's approach and things like that, you can have these sort of different types of bullying scenarios, sort of the backhanded insult, the quiet sort of the targeting, specifically the loud, angry approach. I feel like it can take lots of different forms. The way that an individual might approach someone else, and it could, a lot of different things could be considered bullying by the individual receiving the conduct, or perceived that way anyway. One really fascinating issue, I don't know if we'll get into it today, is the struggle we sometimes have between perception of bullying and the facts on the ground, and then definitions, especially in the private sector context where we're dealing with codes of conduct, harassment, discrimination policies, but there is no common definition of bullying there because one hasn't been created yet.
Yeah, so there's no definition in the statute that relates to schools to was it's 28 MRSA section 1001? Yep,
it is. Yeah, I'm actually talking about in the private sector context.
Okay,
there. I was
right.
differentiating between the two, that because there isn't a more commonly accepted definition of sort of workplace bullying, or a law prohibiting workplace bullying, however it might be defined specifically, you're left to see what the behavior is and then what other boxes it might fit into, like violations of code of conduct, or your harassment or discrimination policies.
Yeah. So you mentioned earlier harassment. So it seems like it's kind of hard to define the lines here with what is bullying, first of all, but what about the difference between what's harassment versus bullying? Or is there an overlap of the Venn diagram?
Yeah, I'd say there's substantial overlap. Using those terms may be in the eye of the beholder, but I tend to think of harassment as getting more severe. We also tend to use harassment in the context of protected classes. And that's certainly one thing to have an eye on. Going back to Alex's sort of summary of what bullying is, as someone looking in from the outside, that's what I'm going to be looking for. Because if it does invoke a protected class, then you have other legal options, Amendment Rights Act, things like that. So I don't think that's a perfect bright line definition, but that's where my mind goes to anyway, when you talk about bullying versus harassment. But I do think there's, to a large degree, overlap.
I totally agree with Ben. Sorry, Shari, is it okay if I jump in with the?
Yeah, definitely jump in.
Didn't want to cut you off there.
Oh, no. No.
Yeah, no, I agree. I think, that Venn diagram does have a lot of overlap, and bullying, the cases I see where bullying is, might be harassment. Yeah, are those situations where either, a protected class is clearly at play, or the really difficult ones where there's a concern or allegation about bias, that, sort of non-obvious discriminatory conduct might be based on a bias, which would relate it to a protected class, which might make it discrimination or harassment. And right, figuring out where those lines are and which policy or procedure to apply when, you know, addressing the concern as the employer and trying to get that right. You know, sometimes it's really clear and other times it can be a little more difficult. But I think that parsing out is really important, an important exercise for the employer to do, to figure out, you know, where and how they should be processing the complaint.
Yeah. So what about, you know, the difference between legitimate performance management and bullying? I know so much of this is about perceptions, but, you know, for example, sometimes bullies use excuses like, oh, they just don't like being held to high standards, and that I'm not being a bully. They're just, you know, not working hard enough or whatever. Do you run into that kind of a thing?
I actually don't think that's a common scenario. I think it is more common that it's, we've already talked a lot about folks from the outside, but I think within the workplace, it's going to be more coworker on coworker problems than something that's in the direct supervisory role that's blurry. I mean, we certainly see bullying, harassment, supervisor to supervisee, but I rarely see one where it's a close call like that. It will often have you know, sexual component, something like that's very clearly not part of a job performance issue.
Yeah,
Yeah, go ahead. I was just going to ask you the same question.
yeah, I agree with Ben that often you know, if it's a straight performance management issue, don't see as many of those where we have bullying complaints. I will say, in the school context, you know, one thing we even call out in this policy that we put together on this is, you know, an example of something that isn't workplace bullying is when supervisors set reasonable performance goals and provide verbal, written counseling, direction, feedback, et cetera, to work with the employee to meet those goals. I've had a couple cases though where, and actually so far only in the private sector context, where I have had employees say, and you know, they haven't classified it as bullying necessarily, but in some cases it's really, that's sort of the only way you could talk about it, or they've called it bullying even though there's no definition of bullying, where they've said, look, I'm being unfairly targeted for my performance by my manager, and you know, look at Elek, he's having the same, you know, issues that I'm being written up for, and he's not being written up, you know, so you know, my manager doesn't like me, or maybe they're targeting me because of a protected status or whatever. I've had a few of those different concerns over time. It's because of my disability. It's because I'm a person of color. It's because of another protected status. And there it is important, right, for employers to think carefully about those concerns and not simply brush them off, because right, you could be dealing with a code of conduct issue, and you might even have a harassment or discrimination complaint on your hands, particularly if protected status has been raised. And then it's important to figure out what the manager's doing. You know, are they treating everyone similarly, you know, applying similar standards to similar positions and people, and then enforcing those rules the right way. So I've had those cases, a few over the last few years, and then sometimes you have that personality conflict issue, right, where it's just the manager's style does not line up with the employee, you know, the supervisee's style and personality, and so there's a perception of, right, some sort of bullying or being, you know, the supervisors being mean or whatever in the way that they're going about trying to address the performance issues, and figuring that out, you know, is that legitimate? Is it not? Is it, you know, because we all probably know, you know, folks don't always have to perfectly get along in the workplace, but at some point there's a line there, you know, and have we crossed it? So those are the couple times where I've had that scenario come up where there's been some work to be done.
I think, just playing off that a little bit, I think some of the tougher calls for me is when the employee is a local union leader, right? So the employer can still have legitimate job evaluation of the employee, but you know, that personality conflict is probably heightened in a lot of places, especially where there's been, you know, like a recent tough negotiation or something like that. Because that's another class that the employer has to worry about, is that are the labor violations, right? So is this is this retaliation for protected activity, or is this legitimate job evaluation? I just think that's a tough call on both sides, frankly, when the employee in question is a local labor activist or labor leader.
So, has it been, though, you talk about I think, Ben, you mentioned there's been more this coworker thing as opposed to the supervisor coworker. Is that not been the same experience, Elek, that you have had?
No, I think it's hard to pull percentages off the top of the head, but I think generally, yeah, the higher percentage have been, calls I get about coworker to coworker, concern around bullying or mistreatment. But occasionally I'll get this, the supervisee will be complaining about the supervisor for certain reasons, based on certain things. And those are those couple examples I just mentioned of when there's sometimes there's something to that. We need to really figure that out.
Yeah. It must be difficult sometimes to figure out whether it is bullying or if it's just somebody's personality and just not great management style. Does that ring true? So what are some examples of how bullying can be detrimental to the workplace as a whole and how it can cost money and those kinds of things? Whichever one of you wants to jump in first.
Well, those of you who know my background probably won't be surprised at this answer, but I immediately go to things like are there workers' comp implications, right? So in a scenario where someone's being bullied and it results in medical treatment or counseling or something like that, then you have a whole another body of laws that are implicated, and certainly that's a cost for the employer. There's time out of work, there's medical expenses. This is certainly an area that you can get into really quickly if the person on the receiving end has fairly bad reaction to it, which can often be understandable.
Yeah, go ahead.
Yeah, that's a good example, actually, Ben, the workers' comp side of things. And in addition to that, you have, obviously, to the extent that, an employer has to consult legal counsel, there's an expense associated with that to help, process these things. And often, right, that happens if an employer can't deal with something or doesn't deal with an issue at, an early time when it first comes up, or we might be able to nip it in the bud, and then it metastasizes and becomes a bigger issue, and then, right, legal counsel gets involved. And so there's expense related to that. And Ben touched on this, but there's to the extent someone does end up missing work because of, these issues, there's the just potential disruption to the workplace. Even if someone isn't missing work, if two people need to be able to work together and they can't, right, then you have managers getting involved to try to figure that out. That may be impacting their coworkers' work as well, to the extent that any of it needs to be moved around, or the people need to be moved around, or things just aren't getting done. So, productivity is a concern. And then, these things can really expand and become major problems in whole departments, especially if, you have folks starting to take sides, and it really it can take over in some cases from what people actually need to be doing day in, day out for their work. And so, and that's not even to get into the fact that, yes, some of this could be discrimination or harassment, and you need to make sure we're processing it at the right level to address those things. Because if we don't, right, there's potential legal exposure for these sorts of things too. So it can impact the workplace, I think, in a lot of ways.
They can also have a pretty long tail. So if it's two employees who remain employed, they sort of get things sorted out. I think it's people separated, they still might be in the same, working for the same company for many years, and they might have to be kept apart for many years. That can tie employers' hands if they're, especially in an industrial setting where they are moving people around constantly. They've got to potentially keep keep two people apart, in the long run.
Well, and I would think with today's labor market being what it is too, that losing people because of that kind of a work environment is just making it that much more difficult. I mean, right now,
Yeah.
retaining good employees is.
Well, not even just retention, you mean moving people around. I mean, let's say hypothetically you make ships for the Navy, for instance, and you're in a production department, you get moved somewhere else, it's going to be harder for the employer to fill that spot they've just had to create by having to separate people.
So if someone feels like they're being bullied, what would be the appropriate action to take? That's a pretty broad question, actually.
Well, obviously, I want employees, if they're organized, to talk to their union rep, right? Just get the benefit of the contract going. Obviously, it's going to depend on where it's coming from. Trip to the supervisor is good if it's a coworker, but not very helpful if it is the supervisor themselves who are on the other end of it. Elek, what do you tell your folks?
Yeah, I mean, the one sort of easy answer is, yeah, you need to have a system through which people can report, right, workplace related concerns, and whether that's to the supervisor, or if the supervisor is the concern, then right, there should be someone else that person can report to, so that HR can get involved, and assuming that's appropriate, and that the issue can be addressed in the proper way, whatever that is. Whether that's looking into it, investigating, not substantiated, looking into it, investigating, yes, substantiated, we're going to remediate in some way, whatever the process is, but making sure that folks have a place to go with legitimate concerns, I think, is really important. At the same time, I get calls about cases where sometimes it really does seem like the perception of the person who believes they're being bullied is really off base with what's happening. And in those cases, you don't necessarily want to encourage reporting all the time, because it becomes its own burden. But, we can't really shut those things down, certainly not off the bat. And dealing with repeated false complaints or repeated misplaced complaints is a very complicated legal area, which we can do, but you would not want to do that without, I think, consulting with legal counsel. And then there's always the, in an ideal world, two people maybe can work it out on their own. I'm always hesitant, right, and I think employers are hesitant to suggest that in some cases, because it could make things worse, and you don't know necessarily how bad that dynamic as a relationship has become. If you just tell someone could you just work it out? And that's, in my experience, a common complaint if something does rise to the level of, right, a lawsuit for discrimination or harassment, if protected classes are involved, where folks say, or at the very least, to Shari and Ben, your points, retention issues and unhappiness with the workplace. If someone says, yeah, I went to HR, they just kept telling me to work it out ourselves, if we're beyond that and they're just not listening to us, that's not a system or a workplace you want to have as an employer, a good employer. So it's really great when people can do that, but it's seemingly rare these days, for better or worse.
Well, and that response can also get the employer in even more hot water. Not only is there bullying, but there's a failure to address it. Now you've looped in others who are going to be liable potentially. Yeah.
Yeah. So given that, when would it be appropriate to, or is it appropriate to bring in an outside investigator to look into a certain, particular situation?
Well, my quick take on that, or at least some scenarios or factors that I consider, I'll encourage employers to consider, are things like, on the employer side, there's sort of the practical needs and realities. Is there someone who in-house who's trained to conduct investigations, particularly with respect to these sorts of issues? Is there capacity to do that? And because you don't want to let these things just sit there and take forever before we actually investigate and move them forward. So Those sorts of, questions and concerns. What's it going to cost if it's going to be an outside person? And, and have we accounted for those costs somewhere in our budgeting and things like that? Because I tend to see investigations falling into three categories in terms of the investigator. It's someone in-house at the employer. It might be sort of legal counsel, general counsel. I tend to be sort of general counsel to employers. So I get calls on a regular basis about employment related legal questions, and sometimes they might want me or the law firm to investigate a matter. And then there's the third party investigator, another person who's hired, who's an expert investigator to come in and investigate an issue. And one key question I think about when we're considering hiring an outside investigator, a third party is, and oftentimes when I'll suggest we bring one in is, what are the challenges going to be to this whole situation and this matter? For example, and do we need to try to insulate the employer from any complaints about bias or preconceived decisions or pre-made decisions, and have someone who's at least going to be perceived as more independent conducting the investigation? I had a case a year ago, maybe, workplace bullying complaint in the public sector that also had an overlay of bias concerns, but the person hadn't really raised them as discrimination or harassment issues, and so they were processed as bullying issues and complaints. And it seemed pretty clear to us from the beginning that anything the employer did itself, or even I might have done as legal counsel for the employer, was probably going to be heavily questioned as to, well, you already made this decision. You were never going to find that there was bullying in this case. And the complaints were bullying related to high level, executive level employees. And so to try to avoid those concerns, since that was not the case, of course, and didn't want that to become the issue rather than the underlying situation, we brought in an outside investigator to investigate the matter, again, to try to insulate from those claims or complaints.
Yeah, so there are certain circumstances where it's really beneficial to have somebody who's perceived as neutral, as opposed to, well, I'm sure that, what you do, Elek, is completely fair. That it's nice to have someone who's not working for the employer's law firm in some of these situations where that's really needed for trust reasons.
Yeah, I think so. Yeah, I might do the exact same thing that the investigator would do. We might have the exact same investigation, but the outcome is just potentially more subject to question or challenge, especially in a case where we knew this employee was really distrustful and most likely would, have concerns and raise concerns about that we just did not want to make the center of the issue.
Right. So you've talked about some ways about managing bullying and whatever, but are there specific recommendations that either of you would have for creating a workplace where employees feel safe and free, from bullying, or at least if something like that goes on, they know exactly what to do?
Ben, do you want to jump on this one first, or?
Well, I tend to think the larger employers have good systems set up. I think they tend to have pretty decent training when someone's onboarded about what to do and where to go. I don't know. To me, it comes down to just good management. If you have an involved, sensitive supervisor who's got their pulse on the people they're supervising, I think these things tend to not happen. So, that's where I start. It's not something that's going to come from the legal department. That's just the culture of the organization. In terms of addressing things, I think it's hard. The smaller the workplace, the harder it is, because it's more like a small family. You can't mix and match. There's less internal options. So someone's more likely probably to reach out to private counsel, and that can escalate things. So, on the whole, I think the larger employers have a decent setup anyway. Whether it produces the right outcome or not, I'm not going to say, but at least I think people know where to go, and there are there's intention behind the processes. So, I'm not sure that answered all your questions, but that's kind of how it.
Well, but you did, you said, I'm sorry, go ahead.
Okay, almost like
No, I was saying, so basically training and good management are some basic things that an employer can do. Obviously,
I don't think you can train away bullying. People, get a bee on their bonnet over things, and that it's going to translate into that kind of activity in the workplace. But I think if you have a good manager, it's not going to. So I go back to the original definition, right? It's about, is it pervasive? It's something happening a lot. If you're a good manager, I don't think that'll go unnoticed. And if you see that type of thing happening, if you're a good manager, you're going to put a stop to it.
yeah. Elek, did you want to add anything to that?
I'll just sort of one way I think about it, and this lines up with what Ben is saying as well. And I think it's sort of in one way is captured by the sort of good management umbrella. But and I'll break it down by private first, and then schools in the public sphere, at least unless and until we have a law that defines bullying in other public for other public employers. But on the private sector side, right, because there is no specific law dealing with bullying, and there's no specific definition of what bullying might be, and people now, I think a lot of employees use the term bullying to describe all kinds of different conduct. It's extra important to feel like you know how to box these things up. And the fact that, bullying may not be a thing in and of itself for you, but right, it could implicate codes of conduct, could implicate, discrimination or harassment policies, or maybe some of your other policies as well, depending on what the nature of the complaint or complaints are. And so working within your good management structure and your systems to identify those things and then process them through, I think is really critical. So having a place for complainants to go, having a good system to process those complaints, and understanding how to box them up when they may not at first blush fit in a particular box is really helpful to working through these things. And I mean, at least in my experience, HR is critical in that, whether you have a big HR department or whether it's someone who's wearing multiple hats and one of them is HR, but that person is probably going to be at the center of a lot of this, and hopefully is a person that folks can look to help process and work through these things in the right way. And then on the public sector side, at least for schools, right, there is that extra box of workplace bullying, and the specific shape of that box is still being figured out. I think we're still figuring that out because the law is relatively new, but it's a little more, it's a little more obvious, I think, when you can put something in that box than it might be in the private sector. But all the other rules still apply in terms of wanting to deal with these things and needing to deal with them in the right way and having a good management structure for that. And then, supervisor training, to the extent we're talking about training, I do think some degree of supervisor training and how to help manage these things, especially if they're going to be expected to do that, is really helpful. Because folks who don't have that background, right, may put a foot wrong pretty easily when we're dealing with complaints about this stuff. Because as we've talked about, right, you have all kinds of different workplaces with all kinds of different ideas about what bullying might be and sort of what's legitimate, what's not. And that's nothing, go tough it out, folks, versus that sounds like a huge thing and let's process the heck out of it. You want to make sure everyone understands what they should be doing, where they are in that process and what their role is.
Yeah, and this it goes along with some of the questions that have been put into the chat. So I think maybe it's a good time to toss some of those out to you. And one, Annalee had this question for actually each of you, and that was, to be considered bullying, does an employee need to behave in a certain way? Like, for example, talking in a loud voice, or as opposed to yelling at another person in the workplace? And what about the public, say, applying for a driver or fishing license in town hall? And, so those are kind of two separate questions. What is the employer's obligation? So I don't know who wants to.
I think the answer to the first part of the question goes back to the original standard Elek articulated earlier, and that's about the reasonable person. What would the reasonable person believe if they were presented with this sense of behavior? So I don't think there's there's a standard for what bullying is, whether it's, shouting at somebody or what have you. It's what would the reasonable person looking at these set of facts believe to be a reasonable response, from the recipient.
Can't get away from that law school reasonable man standard ever, right?
Well, I mean, it's what courts and lawmakers are going to default to when they can't write an actual definition, because it's not really susceptible to clear definition.
Yeah, yeah. Elek, did you?
No, I agree with Ben. The facts are going to matter a lot in any individual case. Yes, there's probably certain conduct that we could all agree is bullying. Profanity laden tirade by one staff member against another, maybe even related to protected characteristics or something. Okay, you could have really obvious one-off events that, whether they're bullying or whether they're more harassment, discrimination, everyone would agree on, okay, it's not okay. But other than that, I agree. It's sort of this reasonable person. How does it affect? Typically, it's multiple instances of something happening, not just a one-off thing, although it could be a one-off if it's really bad. And that has to be assessed on a case-by-case basis.
Yeah. I think the question in there about someone from the public applying for a fishing license or whatever, that probably unlikely to result in some sort of bullying charge, even if the member of the public is being let's say rough around the edges. I think it's I'm going to tend to look for repeated conduct, not just a one-off blow up, unless, as Elek says, it has a really, really severe component to it.
But it could potentially be the same parent who shows up at the soccer game and is behaving really badly and trying to intimidate the coach. I don't want to get into sexist things, but sometimes the coach is a woman, and there's that's something I think that's more of an issue in schools, because the law doesn't really cover the town hall situation, right? So
I was going to say, yeah, in terms of that second half of the question, for schools, if this happened in a school in a different format, someone kept calling the central office and berating the administrative assistant and yelling at them on the phone. And at some point, right, you'd probably get a bullying complaint, and then we'd process it and assess whether it's repeated and severe, et cetera, and how severe, and whether it triggers our policy. And then we'd figure out what we could do about that. But yeah, in any other context, there isn't a specific prohibition on members of the public engaging in certain conduct. So I think it becomes a more difficult analysis of, well, what is the employee saying that this being exposed to whatever this situation is doing to them? How is it affecting them at work? And trying to figure out, as an employer, do you have an obligation to deal with that in some form or another? Right? Is it at this point, I've been yelled at so many times. Yeah, it's creating mental health concerns. I'm going to have to take some time off work because I just can't continue to deal with this. And well, then you have an employee leave scenario, and whether you need to or should do anything with respect to this person in the community who's doing this to the employee, I think a little less clear as to whether you have an obvious obligation, but you either may want to, and you may have some ability to try to deal with it, or you may have a legal obligation at some point. As it relates to that employee. So a little trickier outside of the school context, but I had a case a few years ago for a school unit where, before the bullying law was in place, where a parent, this was an athletic director, the employee was being targeted, and a parent was just incensed about their child's playing time and position on the soccer team, high school soccer team. And as you can imagine, I grew up on Islesboro. The community relationship, family, friends, school overlap was always significant and persistent, and that's true in many places in Maine. And here, the parent and the AD were friends for a long time, and the way we processed it was to try to respond in a few times to the concerns, but at a certain point, they became ad hominem attacks, and there was nothing new of substance to provide about the underlying issue. And we eventually had to say, sorry, you can't communicate with this person anymore. We're actually going to block your email. If you have complaints about XYZ, you need to send them here, but otherwise you have to stop and we're not going to hear this anymore. Now that was before the bullying law, but in many ways, I think it would probably line up with what the bullying law requires. And that was a community member, parent in that case, engaging in that kind of behavior.
Well, and then it also ties in with another question that we had, which I'll read. It says, curious in cases that in a case of bullying, are there usually other areas that are also in violation? For example, a case of bullying also crosses in harassment with employees of protected classes or hostile work environment claims. Now, I know you've touched on that a little bit, but I just thought I would kind of put it out there directly to make sure that this person feels like their question was answered.
Yeah, I would say in that type of case, those issues would subsume the bullying. Like there are good remedies, under the Maine Human Rights Act, for instance. And as you heard from this discussion, there aren't a lot of great options in the bullying setting. So if that's going to be a factor, that's going to probably become the dominant factor.
Yeah, I agree with Ben. I think right under this template workplace bullying document that we have for schools anyway, it specifically excludes discrimination or harassment from the definition of bullying, but right, there are other legal obligations to deal with those issues, and schools have policies and procedures that address those items specifically that they will follow to deal with those concerns. So in that sense, it's taking a bullying concern and putting it in a more proper box to deal with. And as a practical matter, and just a sort of a realistic matter, those procedures are even more robust than what the bullying procedure might require. So you're providing more process, for the folks involved. And then I'd say on the private sector side, I tend to still agree with Ben that if something could be discrimination or harassment, you're not sure, processing it, at least initially, the process you apply to it, do it at the higher level, the more protective level for the folks involved. Whether you find that there is discrimination, harassment, or bullying at the end of it is a related but separate question. Because there are going to be different standards you apply to those terms and concepts. But in terms of process, it's hard to go wrong with applying the more protective process, especially if you think it might apply.
Yeah, I am thinking now. Now I'm thinking again about Annalie's question about the whole applying for a license in town hall or doing something. And even there, I would think that the municipality would want to manage it, whether there's a law or not, to get involved and deal with that member of the public who is treating an employee, or bullying an employee. But
yeah, I mean, we keep coming back to the school setting because that's just where Elek and I do most of our work. But there is at least some obligation to provide a safe workplace, right? And so if the bullier has escalated things and there are threats or at least the possibility of physical action, violence, anything like that, there are further protections you can try to get, whether it's protected from harassment or invoking the dangerous behavior provision under school law, things like that. So you do have to be sensitive to whether this just remains sort of in the verbal category, or if there's an additional element to this, where the threat of physical violence is at least plausible.
And we have had a few, handful of cases where, in the public context generally, for schools, but I think also for others, where depending on the nature of the conduct at issue, the public entity may even issue a no trespass order or something to that effect if someone's really engaging in behavior that is threatening, harmful physically or otherwise, destructive, things like that, where we may have to tell them they can't be present as one way to deal with those sorts of concerns, particularly if we haven't been able to deal with the situation in another way short of that.
So have you seen language about this, or well, I guess what I'm thinking of is that under the school anti-bullying statute, it says that if an affected school employee is covered by a collective bargaining agreement, that the policy is actually subject, the policy that the law provides, you know, about anti-bullying is subject to dispute resolution through the collective bargaining agreement. And I'm just wondering whether you've seen collective bargaining agreements that have language that would address that directly, as opposed to me as an arbitrator thinking, okay, well, I interpret the four corners of the contract and I'm not, you know, if it's not in there, and yet the law says you can grieve it under the collective bargaining agreement, or is it just sort of general language that you could pull out that's in most agreements for the rights of employees or whatever, that would probably cover something like that? So I'm just too roundabout in asking that, but I just, you know,
I don't know, Ben. Yeah. And I don't, Ben, do you want to, I haven't seen personally in my practice, I haven't seen a lot of bullying grievances yet. This is all relatively new. And so I think that is a great question, but I'm not sure I'd have a good answer for it at this point.
Yeah, because usually, you know, if there's a grievance, it's that so-and-so violated Article, you know, 2, Section 3 of the agreement by doing this. And I don't know, as I said, maybe, you know, there's some agreements that have general language about the safety.
I've seen agreements with general safety provisions. I mean, we deal with several hundred contracts around the state that are inconsistent, but there are some out there that have at least make a nod towards general safety provisions. Like Elek, though, I haven't seen a grievance go through yet under one of those. We may or may not be trying to do so. I don't want to say on this call, but you know, we generally favor the contractual process if we can get into it, because it ultimately can result in a neutral decision maker deciding something. So, you know, we are often going to try that.
And if there's that kind of a concern, presumably it gets worked out depending on who the bully is. I know in some school departments it can be somebody who's pretty high up, or the superintendent for sometimes. In any event, but you talked a little bit about policies, and I don't know if this is too broad of a question before we go. Oh, I guess we got to, you know, maybe I should see if people have questions before I even ask you about that. I was going to ask about recommendations for about what should be included in an anti-bullying policy. Is that just too general? Is there something that you have that you could share with LERA or anything like that?
I guess I'll take a quick first crack at this. You know, we've already put together the sample for Maine schools anyway, that has, you know, a definition section and, you know, sort of an examples section. You know, these are things that may be bullying, probably are bullying. These are things that aren't bullying. You know, a report, investigation, little procedure, disciplinary action, appeals, anti-retaliation, you know, notice, et cetera. So we have that already available to our school clients anyway. In terms of so I'd of course point to that as one option for schools. For other employers, you know, I haven't been asked to draft any bullying specific policy or procedure documents. And I think that's true in part because for the most part, I think many employers already have enough policies and procedures that would deal with the underlying conduct that is typically at issue, whether it's just a workplace conduct policy or whether it's more, you know, intensive discrimination or harassment policies and procedures. And I guess there, to the extent that folks are considering policy work, think about whether you could, you know, address any conduct that hasn't fit into one of those boxes by amending those existing documents rather than maybe creating something new. But but I'm sure it's quite possible to create something new as well. But you know, the more boxes you have, the more you have to keep track of too. So not always easy.
True. Does anyone have any questions that you haven't had a chance to put in the chat or that you would like to ask right now? Before I see if there's anything final that either Elek or Ben has to say. Not seeing any hands go up, maybe because they've just done such an amazing job that there's nothing left to talk about. But you got, but now's the time if you got anything else. So not seeing any hand raises. Any final thoughts that you want to add before we? Oh, wait, here we go. Will the law stand up to financial impacts? 2 kitchen staff are arguing. One employee makes the schedule. After the argument, the second employee, not the scheduler, receives a cut in hours, resulting in a loss of wages. This is beyond feeling bad to actual damage to someone's livelihood. So yeah, will the law stand up to financial impact? Now, remembering that the law applies right now, I think the only law really is one that's specific to school departments, right? But, you know, if you even take that out to another, you know, if somebody does have that ability to affect someone else's, the amount of hours a person is assigned.
Yeah, I mean, if our scenario is an organized workplace, there's obviously a huge problem there. If it's not, then as long as it's done on a non-discriminatory basis, that it might fly to reduce somebody hours just based on, you know, some stupid argument.
I agree with Ben. I think it depends on you know, the specific allegation. You know, why is the employee whose hours were cut saying that this other person did that? Is it for a discriminatory reason or a harassing reason? Is it something else? Is it this argument? Could the argument be a violation of our code of conduct if we're, you know, private or public non-school? If it's school, is it bullying in addition to those other things, or code of conduct stuff? And then working through, right, wherever the investigation takes you on, you know, what are the underlying facts and what could they be? You know, what are they, what aren't they?
So before we go, we're going to go to Rebecca for announcements about our next meeting and so off, but didn't know if there was anything else you wanted to add. Okay.
No, thanks for having me. It's good to see a lot of you folks, and appreciate the time.
Thank you. But thank both of you so much for taking the time to be here and to talk about this important, really important subject. Rebecca.
Hi, well, thanks Ben and Elek for that wonderful presentation, and Shari for moderating. It's 1:01, so I'll wrap us up just by saying thanks everybody for coming and announcing that our next membership meeting is May 15th, same time, noon to 1, and our topic is supervision in the hybrid workplace. As subtopics, we have the impact of continued remote or hybrid work patterns, particularly, well, the impact on staff morale, particularly in entities that are allowing multiple forms of work participation, challenges that these environments create for HR staff, and touching on tracking software that some employers may be utilizing. So we hope to see everybody in May. Thank you for being here today.
And I'll just say again about the email list, if you didn't get, well, I know that some people, there was some issue with the link that to this meeting where it worked for some people and not for others, and I'm not really sure what happened there, but I'm talking about just getting on our email list. If you found out about this through someone else, we're going to be trying to update the list, but definitely let me know, and I put my email address in the chat. But it's just sharibroder1@gmail.com, and I'll do it again. If you want to make sure that you get notified. You know, we don't send out anything that's not about official LERA business, so we'd love to get you in the loop. Okay. Okay, well, thank you, and thanks so much to Emily Smith from our National LERA office for hosting this, and we're going to eventually it's gonna be up on the website, and we're gonna be doing that in the future. These meetings will be available afterwards at some time, and we'll notify you about that through the email too. Okay, thanks.
Thanks, everybody.
Bye-bye.